my position, I'm a litigator for the law firm Tenori, Knotts, McKinney, and Dwayhe, and it's my sincere hope that I never meet any of you professionally. It means that something has gone awry. It means that a patient is unhappy. It means that we have to have some very difficult discussions. That said, the discussion so far it's actually been interesting because it falls exactly in line with what my slides are going to be about. And before we start, I have no conflicts to disclose. So first and foremost, for those of you that have not been involved in a malpractice case, the patient has the burden of proving. The burden of proof, as you may have seen on TV, is that idea that they have to reach a certain level of proof or evidence to prove their claim. It's a lower burden than in a criminal case because this is a civil case for money damages. So they have to prove it more likely than not that there was a violation of one of these four elements that led to their damages. So if the plaintiff fails at any level at any one of these elements to not prove their case within a reasonable degree of medical certainty, or more likely than not is how it's framed, then their claim is dismissed and they get no money. That's it. Today, what I'm going to focus on is really this one, number 2, which flows from the physician-patient relationship that's formed when you as a physician or surgeon take on the care of a patient. The phrase standard of care takes on a special meaning within the medical legal realm. And we're going to delve into that a little bit more because I think that it unfortunately won't provide a full answer for our discussion tonight, but it might inform your personal decisions as you move forward in your practice. So these elements, the first being duty, is a requirement for a medical malpractice case. There has to be a relationship formed between the physician and the patient. It's in fact a prerequisite for the claim to even be brought. The physician in that relationship carries with them the responsibility of informing the patient of all risks, known risks and complications of a procedure, and helping the patient make an informed decision about that process of informed consent. And so in the context of intraoperative neuromonitoring, being able to express to a patient what that neuromonitoring can provide and what it cannot provide, I think is going to be one of the helpful tools that we'll talk about a little later. Ultimately, and this is your burden to bear as surgeons as well, you carry the responsibility within the OR for what happens to your patient. There's a slight nuance when we're talking about neuromonitoring, though, because there is yet another set of eyes or another clinician managing the neuromonitoring aspects of the case, and what duty arises there. This is an unsettled area of the law, which was an interesting fact for me to learn. But the closest corollary I was able to find, at least in Michigan, is for informal consultations or the so-called curbside consults. The courts in Michigan have likened the second physician there as the eyes for the neuromonitoring as someone who's providing only informal assistance, and so they view it on a spectrum. So as with the literature that Mike and Dominic have shared with us, it's an unsettled area in the law too as to whether or not there's further physician-patient duty that extends to yet another clinician managing the neuromonitoring aspects of the case. So this is an area I really want to focus on for us tonight. The standard of care really lacks a precise definition within the eyes of the law, but it can really be distilled to the statement you see on the screen here. And if you take nothing away from my discussion with you tonight, I want you to remember this statement here. The standard of care is what a reasonable physician of the same specialty would do or not do under the same circumstances. And that is wholly separate from any guidelines or recommendations that might come from this society or any other. It's different from any protocols, policies, or procedures that are within your hospital system. It's a reasonableness standard. It means that you must do what is reasonable for the patient. And perhaps this will answer Dominic's question about record keeping in terms of using neuromonitoring, is the standard of care doesn't require perfect care, exemplary care, or even heroic care. It only requires that you do what is reasonable for the patient. So it contemplates a whole range of management options, which could include neuromonitoring. It could exclude neuromonitoring. It depends on the patient, it depends on the circumstances. So the link then is the causation piece. This is the so what for a malpractice case. The breach of a standard of care by itself, aside from being a potential quality of care concern or perhaps a sentinel event within your facility, is legally meaningless unless there is a link between the violation of the standard of care and through causation to their damages. So in the example given of a pedicle screw that's advanced and breaches, if there's no damages, if it doesn't cause any injury, yes, you could say it's a violation of the standard of care to have advanced that screw, that extra torque turn, and caused a breach. But if it doesn't lead to any damages, any sensory deficit, any motor deficit, then that claim must fail because they failed to show that causation element. And as I point out here, this is often the most difficult element for the plaintiff to prove, particularly in patients with pre-existing deficits or conditions. So the fact that a patient is coming to you for a decompression or fusion tells me, as your attorney, hypothetical attorney, that they likely have some significant pre-existing problems that even if there is a surgical misadventure in the operating room, we can defend the case still on this causation piece. Then that final piece is the damages piece. And these are those calculable damages that plaintiffs can show: loss of wages, loss of work, those sorts of things. The non-economic damages, the pain and suffering, the sort of squishy damages, as we call them, those are a little harder to prove. And in some states, they're even capped because of that. In Michigan, they are, which makes Michigan a more favorable jurisdiction for defense attorneys and defendants in malpractice suits. So, as I was saying earlier, the reasonableness standard here, I think, drives at the heart of these two, the pro and con of using intraoperative neuromonitoring. The fact that we have such a split, and I think that that our survey from the beginning of this was really, really telling, because it shows this dichotomy within your group alone that says, well, I use it sometimes and I don't. And none of you are violating the standard of care. You're doing what's reasonable for your patients. You have to take each patient as they come, and you have to apply that reasonableness standard to inform your clinical judgment, your clinical decision making. And that is another key phrase that you should remember too, that in your clinical judgment, is it appropriate? Is it reasonable to use neuromonitoring in this patient versus this patient? And as a defense attorney, I can defend that case one way or another, whether you choose to do so or not. It's candidly, I'll tell you, it would be an easier case to defend with neuromonitoring present, because from the plaintiff's side, from the patient side, it shows this extra level of care or thought that you put into monitoring during surgery. And so in the hypothetical that Dominic posited where there's an injury, recognized injury or recognized complication during a decompression or fusion, and it shows up on the neuromonitoring, that has to be included in the records. And it's one of those, you can't run from the facts. But if at the front end of that discussion with your patient, you discuss with them what the neuromonitoring can do and what it cannot do, it sets those expectations, makes the case, if it ends in medical legal case, much more defensible. Through my search for this talk today, I was able to find a handful of cases, some of them are directly on point. There are none involving the technical aspects of actually placing EMG or performing the EMG during surgery. And the cases generally fall in these two categories: a failure to monitor and negligent monitoring. The failure to monitor cases, the plaintiff is going to allege that the standard of care required monitoring, and they will have to show through that causation element that the failure to monitor caused damages to them. There are two cases that really, I think, illustrate this. Kingsley versus Pinto is a case where the plaintiff Kingsley awoke with paralysis after a spine surgeon performed an anterior and posterior spinal fusion from T3 to L2 in a single setting without intraoperative monitoring. It was determined that the cause of the paralysis was infarction of the spinal cord. Kingsley alleged that if the monitoring had been used, the complication could have been avoided. The defense maintained that the plaintiff could not identify at which point in the procedure the injury occurred and could not prove that monitoring would have prevented it. The jury returned a defense verdict. So there we see the causation piece of the puzzle in action, that yes, there was an infarction during the surgery, there was a complication or problem, but we cannot precisely show where or when that happened and cannot attribute it to the alleged breach in the standard of care. This next one is a plaintiff case that involves a failure to use monitoring during an anterior cervical corpectomy with a migration of the graft into the spinal cord. It ultimately resulted in a plaintiff verdict of $7.9 million. The expert witnesses in the case testified that if monitoring had been used, the graft dislodgement likely would have been diagnosed and reversed during surgery. So it's, again, fact specific as to the patient and what's appropriate and reasonable for that specific patient. The other bucket of cases that I've seen here are negligent monitoring, that when a waveform change, when there is a signal loss noted within the intraoperative monitoring, what the surgeon did was unreasonable. These are more difficult to prove for the plaintiff. And this is what informs my slight inclination as an attorney to recommend doing intraoperative neuromonitoring, is because the topics that we've talked about, the clinical decision making, the standard of care being a reasonableness standard, allows for you to explain in a deposition or in your operative note that yes, we experienced signal loss and there was an injury at this level. The two are unrelated. It allows you to put that right in your note. So when a plaintiff's attorney picks up that chart and looks through, they're faced with those facts in black and white, and their experts are faced with those facts in black and white taken at the time of the operation. And I think that those cases, negligent monitoring cases, will actually peter off and be more difficult to pursue for plaintiffs. So I want to leave you with some best practices, and these are good takeaways, I think, for any physician. But be as descriptive in your operative reports and note your reasoning for using or not using. Like I said, as a defense attorney, I can support either. Experts will support either. But the more descriptive you are in your operative report, saying that this patient is a candidate or this patient is not a candidate for neuro monitoring during surgery for these reasons, makes that aspect of the case that much stronger. So likewise, it might be time to review and revise consents where monitoring is going to be used. Informed consent, we kind of an adage in our world is you can't consent away life and limb. But that being said, if there's an informed discussion with a patient who is fully cognizant of their surroundings and able to consent, it's yet another way to bolster the strength of a prospective medical legal case. And I know from experience with physicians that many of you can kind of get a sense or a feeling for which patients of yours may end up being plaintiffs. And so having this belt and suspenders of revised consents that include intraoperative monitoring and descriptive operative reports when you make that decision on what you're going to use or not use will be, I think, a big help to a prospective medical legal case and lessen the likelihood of that case ending up in litigation. And then finally, and this, I cannot recommend this highly enough, is to stay up to date on current guidelines and recommendations. Those don't supplant your reasonable judgments, clinical judgments, because those are what are setting the standard of care within your operating room, within your own practice. So with that, I appreciate your time. This is a QR code for our website and my direct contact information. I would welcome any of you to contact me directly to discuss this or any other medical legal questions you might have. This is something I'm passionate about and enjoy doing. So please feel free to do that. Thank you.